Speakers today. First of all, Mr. Trey Critelli, who is the Director of the Iowa Supreme Court Office of Professional Regulation. Secondly, two practitioners, Laura Jensen and Travis Kavanaugh. Both of them are with Simmons Perrine in Cedar Rapids. They did a lot of work with development of the forms that are part of the presentation package here, and I know you're going to enjoy hearing from them. My name's Paul Wink. I used to be the Director of the Office of Professional Regulation, and I'm now very happily retired. But I'm happy to be here and talk a little bit about something that started on my watch so that Trey doesn't have to take it all. I'm going to talk first about the rule, the new rule, and the planning process generally. Trey's going to talk about the screens and the menus that will be part of the annual client security questionnaire, implementing what we call the first tier of the rule. Laura and Travis are going to talk about the forms. Now, I'm certain that you're going to have questions, and good questions, about the implementation of the rule. And what we would like to ask you to do is this. Once we're all done talking, we're going to form a panel up here so that we can take your questions as a panel, because we think they're probably going to cut across quite a bit of territory here in terms of forms, in terms of what's going to happen as a part of the client security questionnaire process, and just with respect to the interpretation of the rule itself. And we think we probably all need to have a piece of a lot of those questions. So if you would, let's do it that way. So, purpose of the seminar: implementation of new rule 39.18. Primary focus here today is on sole practitioners. But Trey would tell you, based on our experience at the Office of Professional Regulation, that although we know that issues with the practice following death or disability occur much less frequently with respect to members of the firm, there still is a place for planning for lawyer death or disability if you're a member of a firm. And in fact, the new rule does require that all practitioners make the first tier designations that will be done as a part of your annual client security questionnaire. So we'll visit the status of a firm and firm planning at least briefly here. So first, a short recap. How did we get here? 2005, adoption of the Iowa Rules of Professional Conduct, the diligence rule. In those rules that were adopted in 2005 has a comment 5, that goes to succession planning by sole practitioners in Iowa. So 2005 got the Office of Professional Regulation started on looking at this whole business of succession planning by sole practitioners. And during the period between 2005 and 2015, OPR tried to do a number of things. We got our auditors energized to talk to you a little bit while they were out doing audits about planning. We did some seminars through the bar starting actually in 2004, I think. We published a handbook in 2011, took a look at the demographics with respect to the sole practitioner cohort in the Iowa bar. And frankly, we were a little concerned because the cohort, at least as of a few years ago, looked a lot like me. So forward now to 2015. What we were finding as we did audits was that really only about 20% of our sole practitioners had done anything with planning for disposition of their practices. And the result was then that OPR recommended a rule to the court that would require, essentially implement the comment 5 to the diligence rule, but requiring formation of succession plans by sole practitioners. The court published the rule, very little comment received in response to the rule, so the court adopted it. Then we got attention. And with the support of the court, the effective date of the rule was extended. The Bar Association formed a task force to look at the rule and try and make it something that would work a little better for practitioners. And the rule we're going to talk about today is the new Rule 39.18 that's been reworked with the help of the task force. So let's move on now. Why do we need to do this? Well, we've talked a little bit about the rules. Comment 5 to the diligence rule, of course, was the harbinger for all this, and it's still the basis for this, as we'll see in a few minutes. We have an obligation in the client confidence rule to make provisions for preserving the confidences of our clients, even in the event of our death or disability. So that's rule number 2 that comes into play. And of course, now effective December 25th of this year, we have the new rule 39.18 that comes into play. But there also are some, what I would call professional and personal reasons why we would want to do this kind of planning. Your liability carrier may require it, or may want to know who you've designated as your successive or your successor or assisting lawyer. If you become disabled temporarily or permanently, there may be some economic reasons why you would want to have somebody step in, help administer the practice for a period of time. So there is that consideration. Trey would tell you that based on our experience at the Office of Professional Regulation, that practices that haven't been prepared for lawyer death or disability are a leading cause of claims against the Client Security Trust Fund. Generally, it's for retainers that are just not properly accounted for, but regardless of the cause, it costs all of us who support that fund money every year to help maintain the fund so we can pay those claims. We also know at OPR that practices that are just not well organized and ready for an event frequently result in appointment of a trustee by the district chief judge under the provisions of what we now know as rules 34.17 and .18. And the trustee, of course, administers the practice, and generally the Client Security Trust Fund gets the bill for that as well. So there's a cost factor there. And of course, there's just the idea of showing our clients one last bit of professionalism so that they know that we cared enough to make sure they got taken care of even after we were gone. So the diligence rule. This is the 2005 rule from our rules of professional conduct. Comment 5 is the key part of this. Now, comment 5 is up there on the slide. What I'd ask you to just consider are the first 6 words of the comment. The key theme here, and you're going to hear this all the way along, is protecting the interests of clients. That's what this is about. And that theme, if you will, is the basis for the distinction that we're going to talk about between the first tier planning requirements of the new rule and the second tier provisions, if you will, of the new rule. Because the first tier is focused on minimum things that we need to do to protect the interests of our clients. The second tier is focused on optional things that we can do with respect to administration of the law practice in those areas that don't necessarily directly affect the clients. So that's our diligence rule. We do have some other rules that come into play. We have them listed on the slide that you currently have. I think there are really 5 of these that come into play with respect to that first tier requirement I talked about. 32:1.16, withdrawal from representation of clients when our mental or physical condition materially impairs our ability to represent them. Okay. Once that happens, it triggers some obligations to notify clients, or at least see the clients are notified, return papers and property of clients, and refund unearned advance fees. You're going to hear those things pop up a little later on as we talk about things that have to occur as a part of the implementation of the first tier actions under the new Rule 39.18. 1.9C, revealing information relating to representation of a former client, does say that there's an exception to that for ethics rules that require you to share information. And of course, the new Rule 39.18 is going to require that you share some information with your designated attorney. So, read literally, we would not need to tell our clients about the existence of the designations that you're going to make under Rule 39.18, but prudence would suggest that I think if we have agreements with clients that we use as a matter of course, we still might want to let the clients know that this is happening, so that if something happens, they're not surprised by the implementation of the plan. I spoke a minute ago about Rules 34.17 and 18. Those are our trustee appointment rules, as recently renumbered. 30.17 goes to the appointment of a trustee by the chief judge if you are disabled. 34.18 goes to appointment of a trustee if you're deceased or disbarred or suspended for cause. And a trustee can be appointed in that situation if a reasonable cause exists. I think it's important to note what those rules are about for this reason. There were some changes to both of those rules incident to the adoption of Rule 39.18. And basically they're intended to allow the chief judge to consider a designation you've made under 39.18 if the judge finds it necessary to appoint a trustee. It'll function, we think, much like a standby nomination of a conservator or a guardian in that instance. But it's important to keep those rules in mind also because the designated attorney has the authority under the new rule to ask for appointment of a trustee under whichever one of those provisions would apply, basically for any reason that the designated attorney thinks it's beneficial or appropriate. And we're going to talk about some circumstances when that might happen here as we move on. Now, last of the 5 rules I want to talk about in the context of Tier 1, if you will, is 45.11. We've had this rule for a couple years now. This is the rule that allows you, if you are the sole attorney signatory on your trust account, to designate someone to be your successor signatory if something happens to you. And there are a list of contingencies in the rule that actually are broader than Rule 39.18. Okay? The key thing that I would want you to know at this point is that 39.18 says that your designated lawyer has these powers that otherwise would arrive under or arise under Rule 45.11, because we want them to have the ability to administer the trust account. Okay. With that having been said, we're going to talk in a minute also about how it probably still is a good idea to have a standalone successor signatory agreement in place that you've shared with your bank and that the bank has indicated to you that they'll honor, so that we don't run into issues with banks after the fact. Okay. All right. To the heart of this, 39.18. It will be effective December 25th, 2017. Basically, it's going to be effective for the 2018 lawyer reporting season. So the client security questionnaire that you submit that will be due March 10, 2018 will require that you answer the questions associated with the first tier duties under 39.18. Now, what's in the first tier? If you are in private practice, you will have to complete this first tier. Now, if you're a member or an employee of a law firm, and the law firm has other lawyers who are licensed in Iowa and in good standing, you can just designate the law firm as your entity, your designated entity who's going to perform the things that the rule requires upon your death or disability. If you're in private practice, but not in Iowa at all, you can essentially check mark a block for that, and you don't have to fill out the rest of this. Okay, but otherwise, if you're in private practice in Iowa, you're going to fill out all of this, and basically it's going to require that you designate another Iowa attorney in good standing to help you, or there are some other possibilities that we'll get to in a minute. Okay, the second tier. Now let me back up a minute and just emphasize the first tier. Those designations in the client security report form are required. They will be required. Okay. Now, the second tier provisions of the rule are entirely optional, and these we don't have any reporting mechanism for you to use. For these, you have to essentially craft your own agreement. Why would you want to do that? Well, the rule allows you to have this optional supplemental plan, if you will, that could provide for administration of the firm, collecting fees that are due, terminating leases, generally closing out the practice. And the forms that can do this have been drafted if you choose to use them, and Laura and Travis are going to talk about those in a few minutes. So before we get into this any further, I think I need to clarify some definitions. I've used the term designated attorney with you. By that, I mean the lawyer that you have chosen and designated in your client security report as the person who will administer your practice in the event of your death or disability. That's the designated attorney. Okay, you making the designation are the planning attorney. Simple enough. Okay. Now, we talked about the fact that you could use someone other than just another Iowa lawyer as your designated attorney, and we have this concept here of a qualified attorney servicing association that's in the rule. It's going to be interesting to see how that develops. It can be a bar association, all of whom, or at least a part of, has members who are admitted to the Iowa bar. It could be one of the professional liability companies that sells insurance to Iowa lawyers. Could be a bank with trust powers here in Iowa. It is permissible for you to designate one of these entities as your designated attorney or entity. It's also permissible to designate a law firm. It doesn't have to be your law firm. It could be another law firm in Iowa that has at least one active Iowa attorney on board and is willing to do this kind of work. Okay. Now, there may be an opportunity for someone who wants to accept a little risk to get into this business here of providing these services. And we're going to talk for a minute about how someone might do that and limit their risk and make this something that can work. But at this point, I'm not aware of any bar association or bank or professional liability insurance company that's jumped into this yet. We'll have to watch that. Okay. First-tier designations. Here's where you identify another active Iowa lawyer, law firm with at least one active Iowa lawyer, or one of those qualified attorney servicing associations. You also will need to do in your client security report, you'll need to tell the Client Security Commission where your practice records are located, including your client list. Now, let's just pause for a minute and talk about the designee. There was some concern at the task force discussions about the ability of all of our attorneys to come up with a designee. I want to suggest to you that your ability to come up with a designee who's willing to do this work for you will vary directly with the quality of your organization, of your practice. A good client list, good organized client files, up-to-date trust account records are going to go a long ways towards convincing somebody to take this on, okay? On the other hand, frankly, if a practice is like some we've seen that have been administered by trustees where files are not maintained in a disciplined way, retainers are not properly accounted for, you're going to have trouble, I think, getting somebody to act as your designated attorney. So now, with that having been said, if you're asked to serve as a designated attorney, I think there are some things you can do to reduce your risk, okay? The first one is have a close enough relationship and be familiar enough with the way you're planning attorney practices that you have some confidence about the quality of their practice organization. Just don't accept the designation and not go get familiarized and meet their troops and find out how they practice. The other thing you can do, though, you can always do this. If the eventuality comes and your designation is activated and you get to the practice and find out that unbeknownst to you, Joe, the planning lawyer, was very depressed for the last 6 years of his life, and his office is full of loose papers, the files are not organized, there haven't been any entries in the trust account records for 3.5 months. You always can file the application with the district chief judge to say, this is more of a mess than we thought it was going to be. I'm concerned about getting paid for doing the work. Please appoint me to be the trustee, or if you don't want to do it, ask the chief judge to appoint somebody else to be the trustee. Okay, so there's an out for you here in those situations where it's really warranted. Okay. Authority of the designated attorney or entity. By making the designation in your client security report, by rule, you authorize the designated attorney or entity to perform certain actions on your behalf. And you remember that because this is the first tier, we're talking about a fairly limited set of actions that are focused on just protecting the interests of clients. So what are those? Reviewing client files, notifying clients of your death or disability, administering the trust account, determining if there are other actions that are necessary. Those are the things the rule says. I would suggest to you that if we consider some of those other rules that impact this situation, that the other actions that are going to be necessary are going to include returning files to clients, refunding unearned money that's in the trust account, zeroing out the trust account. And also, it may be necessary to advise the court about the situation if, in fact, there are short-term events coming up that the district court or perhaps even the Supreme Court is going to need to know about. Now, Rule 39.18 gives you some support as a designated attorney. The first item of support is this. If there is some question about whether 39.18 really has been triggered, now, hopefully in a death situation, we're not going to have that kind of question, but a disability situation definitely could have some question. And of course, your planning attorney can address that in a supplemental agreement, the optional supplemental agreement if they want to. But if it hasn't been addressed in terms of what is the basis for finding disability, you can apply to the chief judge for a determination on that, so you feel confident in assuming duties. Okay. The other thing, of course, you can do, and we've mentioned this, is that you can petition for appointment of a trustee under the provisions of Rules 34.17 or 18. Now, I really recommend that if you are contemplating serving as a designated attorney, or you're asked to serve as a designated attorney, flip back to Appendix E to the materials that you have. What we've done in Appendix E is try and operationalize, if you will, what are you really going to have to do if you're the designated attorney and you're pressed into service here. And in order, they look like this. First of all, confirming that you do in fact have a death or disability. Making sure that you've got proof of your authority. Now there's a form we're going to talk about in a minute that gets printed out off your lawyer account page that you sign and you give to your designated attorney. Okay, you want to make sure you got the document you can use to show people so they just don't laugh at you. Okay, you want to access the files and records, and then I think you really need to sit down and assess the situation. Does the practice look like it's tidy and you can get it done and get paid within the construct of the designation under the first tier of the rule? If it doesn't look like you can make that happen, then that's the time you probably want to talk to the chief judge about a trustee appointment under 34.17 and 18, if nothing else, to make sure you get paid. Okay. Now, once you've assessed the situation, then we're into the real work here. Notice to clients, getting files returned to clients, doing the reconciliation of the trust account, see if everything's there, and parceling money from the trust account out to the clients who are entitled to it. Figuring out what you're going to do with the remaining files. And by the way, we're going to talk about files in a minute. Files and trusteeships have been one of the most nagging issues that we have. We're going to talk about why, but you know, if you look at those duties in Appendix E, and you contemplate an attorney who has a relatively tight and tidy practice, you know, that's really not going to be too bad. But if the practice isn't tight and what I call tidy, that's a potential issue. So, okay. As a planning attorney, what do you have to do? What's the implementation here? Well, first task, engage another Iowa attorney or law firm or one of those qualified attorney servicing entities to be your designated attorney or entity. I think you'll want to familiarize those folks, whoever you designate, or the rep of your designated entity, with your office procedures. Introduce them to your staff. Give them some familiarization with where things are in your office and how you do business. You will want to brief your staff. I think you want to brief your family on how this all works, so that they can be a part of the solution if the time comes. At least know that, so that they know who to contact and how to get them essentially in contact with the things they need. Now, besides identifying the designated attorney and then listing where your practice records are, you have to specify something called a custodian. This term custodian, I think, is, it's not intended to imply that some person other than you has physical custody of your client list or your files or any of those kinds of things. But the intent is that there be some person other than you who's knowledgeable about the location of those things and can assist your designated attorney or entity in getting access to those things when they need them. And you'll have an opportunity to say who that custodian is as a part of the reporting process. Now, some examples that occurred to me. Your custodian might be a law firm staff member. If they have a key to the office and they know where everything is, that's pretty easy. If you don't have law firm staff, maybe your custodian is your spouse or significant other who has a key to the office or can get to the key to the office and has a general idea of where things are. If you don't have one of those people in your life, I suppose you familiarize your designated attorney with where things are, and assuming you don't want to give them the key, maybe that's your landlord. But I think you can kind of work through that and come up with a common sense approach to that. Now, once you've made the designations under 39.18 as a part of the client security report, you will be able to push a button on your lawyer account page and produce an official form that makes the designation and specifies what their powers are under the rule, so that you can sign that and give that to your designated attorney. Now, if for some reason you don't do that, or your designated attorney can't find it when the time comes, Trey is going to be able to print one out at his place. And one of the directors or assistant directors will be able to sign that variant of the form that confirms the authority of the designated attorney to do the things they're supposed to do under the first tier. So there you go. That's a full and equal opportunity employment for Trey and the assistant directors. So, okay, implementing the second tier options here. We don't have a form for this. Well, we have forms for this. We don't have online reporting mechanism for this. Is what I meant to say. You'll have to draft your own agreement for this, and our friends from Cedar Rapids here, Laura and Travis, as a part of a really great effort by Iowa Trust and Estates Council, have drafted forms for us. They're going to talk about these in a minute. So I'm not going to venture there. I think I'll leave that to them. There are just a few more things I want to talk about here. Preparing the practice. We've seen in the context of trusteeships that unprepared practices are a source of a lot of confusion, tremendous amount of work for trustees, and ultimately a substantial delay often in getting clients fixed up with their files, getting the money returned to them that should be in the trust account. And those are things we're trying to prevent with the rule here. So I would tell you that the best thing you can do all the way around with your practice is get prepared for this, okay? And the first general category that I think is and you heard me use these words earlier, an organized, tidy practice. What do I mean by that? Having the ability, either your staff or your software, to produce a good, accurate, current list of active clients, names and addresses. A good calendaring system that can be reproduced with coming deadlines for clients. Up-to-date trust account and billing records are key. a law office list of contacts, especially if you're going to use that second tier optional provision to allow your designated attorney to do other things than just those minimum things that protect clients. Okay. Avoid keeping original client documents in your records. What does that mean? Don't hang on to abstracts if you don't have a business purpose for having them anymore. Think carefully about hanging on to original wills that belong to clients. Think carefully about hanging on to original conveyance instruments, because those things are all property of clients and they're going to have to go back to clients once you're gone. If you do keep those, segregate them from the client files and keep a good log and index on them so that they can easily be separately administered by your designated attorney or the trustee. Okay? Periodically purge your paper files. You know, I have to tell a story on my own firm. You know, we had decades of paper files down in the basement. And certainly there was some value in being able to go down there to reconstruct an income tax basis for something from events that occurred 35 years ago. But if you're a sole practitioner, someone's going to have to clean those up when you're gone, and that can be a tremendous expense. So figuring out a systematic way to purge old files, perhaps convert them to electronic form, or at least go electronic going forward. So that you minimize the files. Now, a second category that I would recommend here in preparation of practice is coordination with a few key parties. First one, professional liability carrier. They should know who you've designated to be your designated attorney. And I want to come back to the bank. We have a real concern on a couple levels with bank willingness to allow some other lawyer to administer your trust account after you're gone. Okay, what are the two levels? Well, we're a little concerned, first of all, about whether they're going to honor the 39.18 designation. Some of the lawyers we've talked about are a little concerned about sharing their planning documents with the bank. With those things in mind, let me suggest to you that perhaps a best practice is to create a separate successor signatory designation under Rule 4511. Take that to the bank and make sure that they will honor that. In fact, you can just leave it with them so that you've got that business with the trust account covered. Okay, personal affairs. A will, and language in it that directs your personal representative to activate the provisions of your standby agreement. Okay. Now, I believe that the forms that Laura and Travis are going to talk about actually use that approach. So I'm going to let that go where it is. Now, client files. The court has adopted what we call the entire file approach to who is entitled to a client file. In Iowa, it's client property, even the work product. So unless you've addressed disposition of files in your engagement letters or some other notice or agreement you've gotten from the clients, you just can't summarily dispose of the files because they belong to the clients. Okay. So the best practice here is to get some kind of an agreement with your clients, you know, whether that's in the termination letter, in your engagement letter, or whatever, that allows you to dispose of the file. But otherwise, what's going to happen is this. Your designated attorney is going to have to go through each file, make sure that there isn't any client property in those, abstracts, wills, original copies of conveyances. Okay, that's a lot of work. Okay, if you don't have that stuff segregated or out of there. Okay, then they've got to give notice to every client that I have your file. you've got until X date to come in and police it up, okay? And at that point then, we're in a position where we can dispose of a file. It's a tremendous amount of work. So the best practices, here they are. Figure out what you're going to use for your normal retention period. You know, our trust account rules say that you have to keep trust account records for 6 years, and that includes anything that supports the entries or the deductions you've made from the trust account. So we typically tell lawyers you might as well just keep the client file for 6 years too, because that's part of your basis for what you've done with your client's money. Okay. Your liability carrier may say longer, and if so, go with that. We've seen up to 10 years from liability carriers for a file retention, but put something in your engagement agreement or your termination letters with the client so that you don't have to go out and get that authority later to dispose of the file. And once again, the best practice here, electronic, so that we don't have the burden of 40 boxes of paper to deal with when you're gone. Okay. Members of the firm. Now, we noted earlier that if you're in a firm and you're practicing in Iowa, you're still going to have to make the designation on your client security report, but you can designate the firm as long as there's another Iowa lawyer there. That's pretty easy. But a law firm can do planning also. Good place to do that is in the organizational document. Things you want to think about. What do you want your lawyers to do pre-death or disability so that things are ready? And what do you want the law firm to do after death or disability to make sure things get handled right? Okay. Basically, those are the things that you want to do in a law firm context. Okay. Trey's got work to do. OPR's got work to do. From now until November, Trey's going to be working on development of all those menus and screens that will be part of the client security report. So you can do that first tier reporting and produce that official form that I told you you'd be able to print out by pressing a button. Trey's got that at this point. And he's going to be telling you, I think, about how the report's going to get filed, what that's going to look like, how you can update a designation during the year. Because remember, when you make a statement to the court on your client security report form in the first part of March, and the information changes in June, you owe OPR a supplemental report advising OPR of the change. Same thing is going to apply with respect to your designations. If they change during the year, you're going to have to tell OPR about it. But we're going to put a button on there so you can update the designations online, just like you do it during the report. So I think that's my cue to pause and let Trey talk about what he gets to do.
Sounds like I got to do all the work, doesn't it? That was a joke. Here you go. First of all, I want to thank Paul for putting all of this together. I mean, he's retired now, and I say he's sitting home with nothing else to do, but that's not true. He's running here and running there, but he's taken really a complex lot of changes and trying to distill them to an easy to follow. At least you can understand what the process is. So I want to thank you, Paul, for taking the time to come here and be with us on this. I'm going to talk a little bit about what it is you're going to see. How are we going to do what we've been talking about? You know what the rule is. How are we going to do between now and December 26, 2017? And I want to show you one slide. I want to bring you back here. Between now and December 26th, the day after Christmas, if you can all go home and take a look at this preparing your practice, this is really what you need to do between now and then. Some of you, I know, have it already done. You're set, no problems. You can do this tomorrow. Some of you, I suspect, haven't even thought about any of this stuff. You've got some time to think about it. So start doing it now. Maybe finish the taxes before the 15th, and then turn to this. It'll be a lot easier. But all the basics and things are here. are things you should be doing anyway. Ensuring your staff can produce a list of clients, addresses and telephone numbers, so they know how to promote the deadlines, all the basic things that you're doing here to prepare your practice for your designated successor are just good practice tips that frankly can avoid probably half of all the ethics issues that come up from neglect, failure to contact, and all that stuff. So if you're looking for what to do between now and the 26th of December when you log in to file your report, look on this slide. So preparing your practice. What you're going to see when you log in is you're to file your client security report. Every year you have to file the 2 reports. Most of you have filed it. In fact, almost all have filed it now. You have your CLE report, which is filed by March 10th, and your client security report. That's the one you fill out and talk about your trust account and, and all your reconciling things and those sort of questions. And what you'll see when you log in basically is going to be the same general splash screen. And I realize that you can't read the 6-point font on the screen, whether you're at home or here in the audience. But it's basically what you're going to see is that basic step 1 on how to submit your annual client security report. And when you hit continue at the bottom, it'll take you to a page that will have, the basic information. Nothing has changed from what it's been, I think, since this was implemented many, many years ago. Your name, your phone number, update your personal information. So all this is going to stay the same. If you filed this year, nothing will be different next year on these screens. That's step 1. Step 2 will have those basic questions. And again, they're very small on the screen, but you've all seen them where you check off yes or no. Have you been reconciling your accounts monthly? Do you have a trust account? Are you putting all the fees in? And you can put yes and no. There'll be the questions on there if you wish to answer them about the pro bono volunteer activities that you've been engaged in. All that will be the same. So nothing will change until we get to the next section. Now, this next section is really where we're going to implement pretty much the rules as Paul's been describing them in 7 questions. And I am most concerned with just the first tier. Laura and Travis are going to talk about the second tier. That's not the required. It's certainly highly recommended, encouraged. It'd be a great thing for everyone to have. But as far as what's required and what am I going to be looking at on behalf of OPR, it's going to be this section, this first tier. And here's how we're going to implement it with these 7 questions. Basically, and you'll find out as we go through them, and these are rough questions. They're pretty much in final shape, but there may be some little twists here and there as we go through them, as we're implementing them and read through them. And if you see these questions and you review them, either at home or here in your materials, by all means, don't hesitate to send me an email if you have any questions. These are definitely a work in progress. We think they're in pretty good shape, but that's why we wanted to release them to you now. You get the benefit of all the members of the bar here to say, does this make sense? Do you understand it? Were there ways we could rephrase this to make it a little easier? We're here to help you. We're here to help your family and here to help your clients. That's the whole purpose. So we know who to call and who we can talk to when something happens to you. That's all what we're trying to do here. So if there's any questions about these, by all means, obviously ask now, but if you redline something, want to get us your thoughts, that would be great too. So, oops, I don't know what it is. When you first log on, it's going to give you the basic description that says who you can designate. Paul has talked about this: an active, viable lawyer in good standing, a law firm, or a qualified lawyer servicing association. So this will be a reminder of who you can designate in these things. You've heard them all now, but we always want to remind you before you go to start putting names in, just remember who it is, who falls in that rule, so to speak. Then the first question is a very simple one. Are you engaged in the private practice of law in Iowa? If your answer is no, you're done. Now, you can always fill them out if you want. But the fact is, that's it. I mean, you're not practicing law in Iowa, you're not in private practice. You don't have a firm that you need succession planning, and there's no client files in most of them. So it's pretty simple that way. For most people, though, you're going to check yes. Then you go on to question 26, which is basically, who are you designating? Who is the designating attorney, as the lingo, the terminology goes? And we need a name, address, phone number, I got probably put an email address on there too. It'd probably be a good thing to add at some point. Just as who do we get a hold of? And that's what this is. If something happens to you, who do I call? Because I don't know who you know. I know a few familiar faces in here, but I don't know who to call. And so this is it. Or if your clients call and say something's happened to this attorney, or your spouse is called and says something's happened to my spouse lawyer, what do we do? Who do I notify? This at least gives us the ability to start to know who to contact. And knowing who to contact is half the problem. We just don't know who. So this is really what this is getting at. Who is the person that you've already spoken with, that you've planned this out with, that you've talked to, that is hopefully expecting this call, unfortunately, one day in the future, and will know what to do, or at least is willing to step in and settle your affairs? Who is it? That's all that asks. 27 is a question that Paul mentioned involving your list of active clients. And it can be found in the custody of a person. That person could be your designated successor. It could be somebody else. But keep in mind that in custody is the best word we found to describe it, but we're not really happy with that word, as you've probably noticed from Paul and myself, because custody, it seems to be like, who's the person that has the list of everything? You know, and I'm not going to give that to somebody outside of my firm. No. It may be someone on your staff. It may be your spouse if you're by yourself in your firm. You know, who has the list? Who knows who the clients are? Who can help your designated attorney? Or as I like to put it is, after someone contacts me and says that you've passed away or you're disabled, I know who to call. I call the person who's a designated attorney, and I can tell them who to call. Call Cindy. She's the custody person. She's the bookkeeper. She's the office staff. We don't know who works in your office. We don't know your spouse or the people that may be involved in your practice in this sense. And that's really what this is asking. Who is the person that knows, okay, your active clients? Now, active clients is the list of active clients. Paul and I have discussed this because we come from different practice backgrounds. Paul had an office practice, and so his list of active clients goes back to people over years, some of whom he'd see once a year. And it came maybe for tax time. And they kept doing that. Many of you probably have a similar practice. And my situation is more like Fred. I mean, we see people once in their life and they're really not happy to see us because they've been in an accident or there's some issue there. And once we're done, they probably will never see us again. So our list of active clients will be very different than what an office practitioner will have. You can decide what it is your list is. There's some guidance that the bar is going to be working on to give you some ideas as to the list of active clients and how far back you go on active clients. And it's going to differ from everybody, but who knows that? Who is likely to have that information? That's who we'll find in question 27. Question 28 basically is the same information except deals with electronic files and records. So who is the person that has the information, the electronic records? Okay, who can access them? Is it only one person in your office that has access to the computer? Or are there more people? Who's the prime computer person that knows where your electronic files and records are? It may be the same person who has the active client list, and we're going to have a little toggle that says you can just hit yes. Okay. It may be somebody different. Keep in mind, we're trying to come up with a list of questions that will fit all different types of practitioners in the state, and everyone's practice will differ a bit, so we're trying to cover everything. So if it's the same person, great, you hit next. If it's not, you put this person down, so we know who will have access to those electronic files. And then paper files comes in 29. Who has access to the paper files? Some firms don't keep the paper files and electronic files in the same spot. Okay. Some are different. Some may have their firms in a virtual office. They're kept someplace in the cloud. They're someone's, one of the bars online Citrix systems or the Clio software I believe you guys have. I mean, maybe that's the key. How do you access that? Someone else has them in boxes in the basement or over in the filing cabinet has the key. So it's going to differ from those two things. Paper files, electronic files. Again, it may be the same person. Just click, you just hit yes. And 30 is my favorite question. It deals with passwords and security protocol. So here's a classic case. Everyone has your favorite device, your phone with you. You've all got a phone, right? Some people are nodding. Some of you aren't nodding. You don't have phones. You're unique in the world. Who gets it? How do people get in this phone? Think of how much business you do. Carmen lives in the phone, doing all these things. And how do you keep in contact with people? It's the same with your screensaver password. How can someone get in your computer if they don't know what your screensaver password is? Or log into your online banking, or log into your Clio, or log into your EDMS for electronic filing. All those passwords and things. Now, I don't want them. Okay, on behalf of OPR, I don't want them. Someone should know how to get a hold of them in your firm. Who's that person that would have that information? Who should your successor, your friend, your fellow attorney that you cajoled into taking the job, you'll do it for them and they'll do it for you, who do they contact? Okay. Who has those passwords? That's the level of the problem we're dealing with, because we get the phone call and no one can break into the computer to find the information because it's all there. So we have to hire a forensic computer investigator to figure out how to hack the system to break in the screensaver, which turns out to be I hate my job or something, and you have to do it that way. I mean, just come up with a list, save it, make sure that people know where it's at so we know who to contact. Again, and this may be the same person as the other ones. It may be someone different. It's all going to vary depending upon your firm. And last, question number 31. Certainly not least, okay, this is, has your designated attorney or entity consented to the designation? In other words, do they know that you chose them to do this? And I would hope all of you would put no. No, I'm joking. I want you all to put yes on this, that they have designated. Okay, because obviously you need to bring them in the loop, and they need to know what's going on. There's nothing worse for someone to pass away, and then you find out that you've been listed as a designated successor. And you're like, I saw this guy speak at a CLE once. I don't know who he is. Now I'm taking over his practice. Same thing. So make sure that they agree. Talk with them. Now, the remainder of what you'll see on the screen is basically going to be all the small print that deals with what's going to happen on the legal side of things as to designating the attorney. And this is some of the language. You can see it in your handouts. It basically says, the authority will take effect upon my death or disability. It's a springing power in that sense. They can apply to the chief judge. Many of the things that Paul had mentioned earlier, that's going to be there. So when you certify, yes, you're making a certification to the court, you've read all of this stuff. And you've seen this on our CLE forms as well as on the client security form, that you agree to it and you acknowledge these things. Again, I'm not going to read through the fine print. It's everything there on the screen as well as the things that this person can do. And you certify you've answered it truthfully. Okay. But there is this duty to supplement, as Paul indicated. So you sign up today and you sign someone and maybe something happens to them, or maybe there's a falling out, or you change your mind, or you need to designate, and that's really what this duty to supplement is. This is the anticipated login screen. We're in the process of coding this, as I mentioned, but this is what it should look like if things go as planned. And basically everything will look the same. You have your general functions, your CLE functions, your judicial nominating elections, all the things you see every time you log in at iacourtcommissions.org. But in the bottom right-hand corner, facing you anyway, it says succession planning. And that's where you can update your designation. So when you click on update designation, it'll pull up, we think it's going to pull up a box that lets you fill out the new information and who the new people are. Probably will walk you through those questions again and just kind of rewrite the data that's in there is from a tech perspective what will happen. But then we have this view/print designation of authority. Paul had mentioned that one of the tasks I'm working on is to have this form that you can print off that will say, I hereby designate this person to have these duties and obligations, and you can take that to the bank, or you have a copy for your file. Or if something would happen to you and the person can't find it, they could contact me or my staff, and we could print that off, and then we could notarize that this was your designation, and you could take it to the bank, or they could take it to the bank and go on with winding down your practice. I would love to show you what the form looks like. It's going to look really cool. Unfortunately, it's not ready for public consumption yet. I've been working on it, and I've got a couple of banker friends of mine that I've been bouncing it off of and saying, okay, here's what I want. It's very small. What language are you comfortable with? And really, I'd like to get many of the bankers to look at it, and the credit unions, just so we're comfortable that it's really something that they've seen. They like the language. If they say it has to be on purple paper, then we'll put it on purple paper. I mean, we'll make it work from their perspective, so you don't have to worry about that. But I don't have any drafts, and I know if I put the draft I have up right now, everyone would scratch their head and say, what's Trey been doing? You know, well, this doesn't look good. We want Paul to get back here and do it. So, but it is coming along. So now we're going to hear Laura and Travis are going to talk about their forms. They actually have some good sample language on what your firm can do, and maybe they'll cover some of those things. And obviously, a lot of what you're going to see from a power of attorney perspective will be similar to what they have in there. But the actual language itself will be forthcoming. That kind of wraps up my section. We'll have some questions or time for questions at the end, but I'll let these two go ahead and take the rest of it because they're dealing with Tier 2, which is very, very important. And again, if I could make it required, I certainly would. So with that, Laura.
Hello. Thanks, Trey. I'm Laura Jensen. As he said, I work with Simmons Prine, and I work with Travis Kavanaugh. And we've been kind of helping to put together these sample form documents that are available on the Iowa State Bar Association's website that will hopefully help you and everyone at least have a starting point in drafting your own agreements if you decide to do this kind of optional supplemental succession planning agreement and the other documents we kind of put together. So I think it was Mike Nelson and the Iowa Academy of Trust Estates Council that contacted our firm, Simmons Prime Moyer Bergman, and one of the attorneys there, Paul Morf, I want to say about 1.5 years ago, back when this rule was originally going to require every solo practitioner, which was somewhat broadly defined, to enter into one of these agreements, and asked if we might be willing to help kind of put together these documents that could be distributed out to sort of help solo practitioners comply with the rule. So that's kind of how we approached it, drafting a lot of these documents back a while ago under that old rule. And that's really kind of how all these documents are focused, thinking about it from a solo practitioner point of view. And I believe under the old rule, the solo practitioner was not just one man or woman alone in a building, but also if it was one person who had equity interest in the partnership or in the practice, I guess, and then you had a couple of associates, you'd still need to have one of these plans, or if it were attorneys that shared office space but weren't really integrated in a firm. So that's kind of the perspective that we had in drafting all of these documents. But hopefully they give you kind of a starting off point, as I think as we mentioned before. Even if you work in a small firm or a partnership, a lot of these are things you want to think about. What should happen if you're disabled or die unexpectedly, and who should be taking over what and under what circumstances. So hopefully they can give people a bit of a good idea for starting. And so as we pointed out earlier, I think the subsection 3 of 39.18 actually specifically provides for this supplemental plan, and it provides that you can designate the attorney to collect fees, pay firm expenses, and kind of do all these administrative tasks that aren't necessarily laid out in the basic rule. So when you make your designation for an attorney under 39.18.1, you're basically saying that on your death or disability that person can then do some of these basic things like trust account disbursements, arranging storage of files, things like that. But with your supplemental plan, you can kind of address a lot of those day-to-day business aspects of actually managing your law firm. And I think that this subsection 3 of the firm kind of points out, or the rule kind of points out, as we've noticed, that there's room for kind of you to delve into the specifics of your plan, kind of, I don't want to say gaps in the basic requirements, but there's room for you to kind of do what works best for your practice and to kind of fill in the details, I guess. But as that part says, it's obviously optional now, so that's kind of the big change from the rule that we started operating under. So I think we've kind of talked a little bit, it's just going through all of the presenters today, why this might still be a good idea. Why would you want a supplemental plan if it's not really required? But I think there are a lot of advantages in taking the time to really think about some of these things while you're here, while you're competent, and while everything's functioning smoothly. This is maybe the best time the only time really that you can prepare for it. And And so one of the things that you can kind of more specifically address when the designation becomes effective. So under the rule, I think that main subsection 1 just provides that it's at your death or disability, and there's says that you can go apply to the court to get that kind of determination confirmed, which you may still need or want to do just to have that court-sanctioned document in the designated attorney's hand eventually anyway. But once we go through some of these documents, you'll see we've kind of put some potential language. Do you want to have your longtime family doctor examining you, or should your spouse and children be selecting the attorney? If there's a disappearance, under what circumstance, on how much time. You can also kind of specify what's a temporary disability and what's, how long is it before we consider this permanent. There's just a lot of those kind of details that I think that you can kind of address if you're setting up a plan now. You can also work through it with the designee, what's going to function. And that kind of goes together with the next point here, that the default powers that are granted to the designated attorney under the rule are somewhat limited, both in kind of broadly what they're covering and then in really limited in the specificity. So like I said, there's talks about the managing the trust accounts and then the files and everything, but if you want to have this administrative tasks kind of mentioned, it's helpful to have the supplemental plan as well. And you can also get more into the details, if you're talking about storing files, if you've already got some kind of plan in terms of how you would like that to function. If you're talking about your administrative, what staff members are essential and need to continue to be paid, and how does that happen, and kind of all those little details that you might want to specify. And like I said, you're working with your designated attorney, so you can say not only what you want, but what's actually going to be feasible for him or her. You might have grand ideas of what you want, but you have to consider what that attorney is going to be able and willing to do as well. And the next one kind of goes with that as well. You can delineate between the powers for temporary versus permanent disability or death. If you're out of commission because you've been in an unexpected car accident or heart attack and you're out for 2 months, you may not want your designated attorney selling your practice or closing up shop or taking all of your clients. Whereas if it's a permanent situation, the things that they're going to be able to do and that you're going to want them to do might be very different. And this allows you to kind of set out exactly what it is that you want, and that's going to work for the designated attorney. And also the designated attorney then can rely on that plan, and it's going to be authority of the evidence granted, and it's going to give that designated attorney some guidance. He or she then is going to have a better understanding of what it is that you wanted and the expectations on him or her. Whereas if it's just under this rule, they might be just kind of flying blind in terms of how all this is going to actually work. And kind of vice versa with that, is that you as the planning attorney get to have this kind of peace of mind that the designee is bound by the plan. We first looked at the new rule, we weren't sure. I think it was Trey's last but not least important thing is whether or not you've actually even talked to the designated attorney. But if you just checked it on the box, maybe you've had an oral agreement or you guys shook hands and said, I'll do it for you, you do it for me, but this actually provides something in writing and you've got kind of a peace of mind that each of you are bound by it and kind of understand the expectations. So I think that those are a lot of reasons why some of these documents are a good idea to think about implementing, even if it's no longer required. So here are kind of the list of the documents that you might want to consider implementing in creating kind of your supplemental written plan. And these are the documents that we've actually put together kind of sample forms for. So the main one is going to be the succession plan agreement that you actually hammer out with a designated attorney. And the one that we've prepared, that Travis is going to mostly go through here in a couple minutes, also talks about kind of an alternate designee. So under the original draft of this that we started working under, I think you were required actually to have a backup and a backup to your backup. So that's kind of how this is set up, which you can obviously tweak, but we've left it all in there even after we went back and reviewed these documents after the adoption of the rule as it's now stands in its kind of current form. That we thought it's still a good idea if you have a backup and something could happen to him or her, or they're unwilling to serve, things like that. So that's something that you can also look at. And then we've got a limited durable power of attorney. So this is something that kind of goes back to what Trey was saying about the form that he's working on to print off right now. We've put together kind of a more traditional power of attorney that hopefully banks would be comfortable accepting, because it would look fairly similar to what they get for anyone's general power of attorney now. And you can also make sure that then it dovetails with the plan that you're implementing here. So if you're just printing something off from the attorney website, it's not going to have some specific powers. If you want to lay out the specific powers you have for your designated attorney, then you can put this together in kind of a limited power of attorney and make sure that everything is working together. And also then you can have something to show to your bank that's not going to give away your entire plan, but shows the authority that you granted. And we've also included some language for estate planning documents, things that you might want to include in your will or revocable trust. It's going to authorize and direct your executor or trustee to act in accordance with the plan and to delegate the authority to the designated attorney as appropriate. And then you can kind of address, whose opinions or whose thoughts are going to control and various things. Selling a law practice is a little bit different than selling the land that's underneath that you might also own. That's actually where the building sits or whatever. There's a lot more considerations, and you might want the designated attorney, who's a practicing attorney and familiar with the practice of law, to kind of control in some of those situations. And so, kind of coordinating that with your estate plan helps work with the executor or trustee who's kind of managing the rest of your estate. And finally, the document that last couple documents, I think we've got a consent action from a single shareholder corporation and a single member LLC that we've kind of put together. They're pretty just basic draft documents, but the idea was basically to just remind people that if you are operating your practice as an entity, that you want to put together some kind of consent action that adopts the agreement and acknowledges the power that you're kind of delegating to the designated attorney and allowing him or her to act as the agent for the entity in the event that the succession plan is triggered. So those are kind of the basic documents that we've set forward, and you can find, I believe all those documents are going to be in the materials that everyone here has, and hopefully everyone on the webinar can also see them. But they're all going to be on the ISBA website, and hopefully there's a link to this that we tried to include in the PDFs. I'm not sure if it's showing up or not, but they're both PDFs and Word documents. So I think the link that we at least tried to include was to the PDF documents so that you can kind of review everything. But we've also included them as Word documents so that you can go in and kind of rework them and tweak them for your unique situation. I mean, these sample plans are just kind of a starting point, and hopefully they can be useful for everyone, but we wanted to make sure that everyone knows that you can tailor it to your own specific situation. Everybody's going to have it different. You might want to grant different powers, and like I said, your designee might be willing to take on different roles, so you can really kind of work with the document to make it work for your situation. So I think the first one that we're going to talk about is the main succession plan agreement, and I think Travis and I kind of go through the basic document and issues with that, so let me go.
Well, thanks, Laura. Like Laura mentioned, I'm going to be going through our form succession plan agreement. This is the primary Tier 2 planning we're talking about. This is optional planning, but I think for most attorneys, this would be best practice to implement this. I know if I was ever asked to be a designee, I'd want to see something in writing to give me, the assurances of what my authority is, what I can and cannot do, when am I actually supposed to step in as designee, and our form agreement, we've attempted to address a lot of those issues. So I'm going to just go through the actual form document as it currently sits. On the first page, we are identifying, the planning attorney is the attorney that's actually adopting the succession plan, and then the designees are the people that you've already identified on your questionnaire, but are now entering into the plan as your designees. In terms of Section 1 and Section 2 of the form agreement, in essence, this agreement, once signed by all the parties, is effective on the date it's executed. However, the implementation date is the date in which a triggering event occurs, such as a death, disability, or other event to which the designee now needs to step in and act as your designated attorney under the rule. As was mentioned, the default rule under the rule that was adopted there's not a whole lot of clear guidance as to what constitutes a disability. And if you have, if you're appointed as the designee, there could be circumstances in which someone appears to be disabled or incapacitated, or just, there's a lot of room for ambiguity there. So the purpose of this Section 3 is to really kind of put finite terms as to when is the planning attorney to which you've agreed to be the designated attorney disabled or incapacitated that I now need to step in as your designee and act. So Part A there, in our form, we've identified 4 events that would constitute incapacity. But however, these are proposed forms, and every attorney that chooses to adopt this will need to customize the form to their particular practice and the facts and circumstances surrounding their arrangement with the designee attorney. So I should note that ahead of time, pretty much all the terms I'm talking about in here are things that if you disagree with or wouldn't want in your personal plan, you could typically remove or modify as you see fit. But under the current form we've put in here, there's really 4 evidentiary things that as a designee you'd want to see before you would step in as the designated attorney. The first one is where you receive a written certification from the planning attorney's doctor stating that the planning attorney is now incapacitated, and once you have that, now you know, okay, I need to step in as the designated attorney. Section B is where the planning attorney himself or herself identifies whatever circumstances are going on in their life. They're not in a place where they can properly perform their duties or manage their client files and practice, and they give you a written notification that I want you to step in as my designated attorney at this time. Section C addresses something that I don't think the rule really directly addresses, and that's a disappearance. I'm sure these are rare, but at the same time, you never know. I heard on the radio recently about the fishermen who were fishing in the Mississippi River and their boat capsized and they weren't found for weeks. So, I think it's important that there be something in there that could address a potential disappearance. In our form documents, in essence, if the planning attorney goes missing for a week, his family and his staff don't know where he's at. After that 1 week, and you're notified of it, you would step in as the designated attorney. And lastly, if the Supreme Court would issue an order suspending the planning attorney's licensed practice, that would also constitute an event in which the designee could step into the shoes of the planning attorney. Another very important distinction to which the rule itself does not address currently is the difference between a temporary disability and a permanent disability. And if I'm a planning attorney adopting a succession plan and appointing a designated attorney to act on my behalf, I'd probably want them to act or not have as broad authority if I'm only temporarily disabled, and I'll likely come back and be practicing again in a few months. So the way we've drafted this form is, in essence, to say if any of those events we've identified above occur and an incapacity has occurred, the presumption is that it's a temporary disability. And that presumption holds unless the doctor rendering the opinion has rendered an opinion that the disability is permanent, or if the incapacity has continued to exist for a period of 6 months or more. Now again, you could modify this however you see fit, but we thought those were some good standards to put in as a template that you can work from. So if either of those 2 events would occur, then you have a permanent disability, which under our form grants you additional authorities that you wouldn't have under a temporary disability. Section 4 of our plan now discusses what authorities am I given as your designee in the event of a temporary disability. And I'm going to run through these, and some of them are pretty obvious. Access to the office, the ability to read mail, open and respond to it, the ability to acquire property of the practice, bill clients, maintain the client files,
Section D, the authority to contact clients and let them know of the event that has occurred, and to take any additional action needed on behalf of those clients. And again, we make reference to the fact that the questionnaire that was completed should identify where they can find the client list and where they can, at least the person that can grant them access to the files and the electronic files. Section F, they're to manage the trust account. Section G is related to fiduciary roles. So sometimes attorneys take on fiduciary roles that maybe are outside, an attorney-client relationship. You're granting the designee to now step in and resign on your behalf if you are in any of those roles. I would say, in wherever you're maintaining your client list, you probably want to maintain a list of any fiduciary roles you're currently actively engaged in as well. Just because I just would think if I came in as a designee, it would be hard for me to know that unless I received something in the mail or some notice from a client asking planning attorney to act in their fiduciary capacity. Section H, in essence, pay the bills of the law practice, pay the staff, bill unbilled time, and collect any and all fees that are owing to the law practice. Section I grants the designee the right to the electronic records and email. J, the ability to obtain or cancel insurance, legal malpractice insurance or otherwise. Section K is one that I think if I were implementing this, I'd want to maybe add a little more meat to the bones. This is regarding the personnel and the work staff of your law practice. Now, if you are just temporarily disabled, you probably don't want to wake up from your coma and find out, all your staff have been fired. But at the same time, there can be, and this I think happens more often than we'd like to think sometimes, is, when a third party comes in and starts reviewing all your records, maybe they're looking at things that you had certain staff members that just took care of for you, and maybe in that review they find out, a particular staff member's been stealing from the law practice or doing some other criminal activity to which, you probably want your designated attorney to be able to take appropriate action in those circumstances to protect, the law practice and your clients. So I think we included it under temporary disability, but you may, when implementing this plan yourself, give some thought to, to what extent I want to grant authority to, say, let go of my staff, and maybe put some constraints on that authority. Section L grants the designated attorney the right to transfer client files, either to a new attorney that's taken on the client or to the client themselves or the client's designee. Now, one thing, and I should mention, in our form we have a number of footnotes, and the footnotes aren't really intended to be part of anyone's succession plan they adopt, but rather to give comment or questions that maybe should be asked by an attorney who's putting this form together. But an obvious conflict of interest could arise where your designated attorney is really the only attorney that is in a position to take on those clients, especially if, say, you practice in a rural community where maybe there's not as many attorneys that practice in the same area as you. And so if you think that is a possibility when putting together this plan, then you'd be wise to at least try to address that within the agreement itself and document whether or not you think, to what extent you're authorizing your designated attorney to transfer files to him or herself. So that, with that kind of circumstances, you could end up in a place where the conflicts of interest could arise, and some of our footnotes are really just intended to kind of make you aware of that and point you in the direction of giving that some additional thought. Disposal and storage of the client files, the ability to terminate leases and other obligations of the law firm, and then just kind of a blanket catch-all authority at the end. So all of those authorities are granted to you under a temporary disability if you're the designee for the planning attorney. So Section 5 is now, here are the authorities you're being given in the event of a permanent disability or death of the planning attorney. And given the practitioner that's putting this in place, you may want to move some of the powers we gave under temporary disability to this section. But as we currently have the form put together, the big additional authority we're giving you in the event of a death or permanent disability of the planning attorney is the ability to decide to close or to sell the practice itself. And the way we drafted this is we assume that the stakeholders of the planning attorney, namely if that planning attorney's died, his beneficiaries under his estate plan, you'd like to give them some say in whether or not they think the practice should be sold or not. And so we drafted this to, in essence, say the personal representative of the estate or of the conservatorship has to agree as to the plan of action as to the closing or the sale of the law practice. And then we've pointed out that obviously a conflict of interest can arise where your designee says, you know, no, I don't think we could sell this. I'm not aware of anyone that would possibly want to buy this practice. And the personal representative and the family thinks, no, there's value here. We should be selling it. And so, you know, you should give some thought to that and decide who should be making that decision. You know, presumably whoever you've named as your designated attorney is an attorney you respect and practice closely with, and you would think would have a better idea as to where the market is in terms of a sale of a practice or not. But at the same time, you want to weigh all the interests that are involved. So, you know, I think one thought is, you know, and I don't know how many attorneys would actually be in this position, but you could give some thought ahead of time as to who in your community would be the potential parties that would likely be interested in buying your practice, and maybe have discussions ahead of time and perhaps implement that as part of your plan. But I think that decision can be a hard decision, especially if the family and the designated attorney does not agree. So when implementing this, you'll want to give that some serious thought. Section 6 addresses compensation of the designated attorney. In essence, the designee is going to receive compensation at their normally hourly rates, and the designee will treat the planning attorney as if that attorney was a client of the designee, and would prepare invoices and the like, and bill the practice as it would any other client. And I think that's important too, because the rule doesn't really discuss compensation for acting in the role of a designated attorney. And depending on the practice that you're stepping into, you might be taking on a lot or taking on a little, but I think it's important on the front end to identify, you know, what's the agreed terms of compensation. So as mentioned, the way we've defined the relationship between planning attorney and the designee is one of a client, attorney-client relationship. And so given the fact that we've defined it that way, one important aspect we've added in this section 7 is to, in essence, say in the event that I, as the designee, am working on your behalf and I'm going through your files and looking at your practice, if I should find anything to which now I'm, you know, I find, you know, an ethical violation or suspected malpractice or mismanagement of client funds, all of which I'd be ethically obligated to report, you as planning attorney are waiving and permitting me to make my filing without that inherent conflict of interest that might exist. Section 8 discusses the alternate designee. This would be the person that is going to step in in most situations, would step in if the designee, for whatever reason, was unable to do so. Section 9 addresses the fact that even though if I'm appointed as your designee and I come into your law practice, there is the potential that maybe we're adverse to each other on certain matters, in which case, ethically, I'm not permitted to take advantage of my position as your designee and look through your client file or whatnot. And under this Section 9, we've in essence stated that when I come in as the designee, I need to identify where I think maybe there is conflicts of interest, and then to whatever extent I find them, the alternate designee can step in for those matters and contact the client and take whatever actions are necessary if there's open cases to which they need to make filings with the court. Section 10 is an important provision, especially if you're going to be the designee for a planning attorney. In essence, the planning attorney and the planning attorney's law practice agrees to indemnify and hold harmless the designee for acting in that role. We've attempted to limit that to the extent appropriate. So, for instance, if the designee takes on certain client files and transfers those to himself or herself and acts inappropriately and ends up facing a malpractice claim of whatnot, those obviously would not be covered here. The intention of this is really to cover you in your role as the designee acting on behalf of the planning attorney. Section 11 addresses the appointment of a trustee. As Paul mentioned when he was presenting, under the rules, you can still go to court and ask the court to appoint a trustee to act on behalf of the law practice or the attorney that's disabled or as deceased. And in essence, under our form, we've stated, I'd want my designee to be that person appointed by the court. Of course, you could still, if the designee steps in and say things are just really bad and wants out and goes to court requesting a trustee, this provision may not always be given effect, but in the event the designee just wants to go to court and get court authority under the Rule 3418, 3417, this provision would clearly articulate the intent of planning attorney that designee act in that role. So to fully implement our succession plan that I've been going through, we've prepared other ancillary documents, one of which is the durable power of attorney. And so that power of attorney kind of works hand in hand with the succession plan. The succession plan is really a laying out of the terms in which planning attorney and his designees have agreed to act in their roles under the succession plan. And the durable power of attorney is, another document granting for the authorities articulated in here in that power of attorney. And as Laura mentioned, we've also prepared consent forms, and these are for practitioners that practice out of a business entity, which is a separate entity from the planning attorney himself or herself. And as such, to fully implement this plan, we've prepared consent actions to grant your designee and alternate designee the authorities necessary by the entities to act on behalf of the entities along with acting on behalf of planning attorney. One point I want to make is, and it's not directly addressed in our form, but if you're, say, in a two-man law practice, and I actually encountered this in a law practice I was helping, where, say there's only two partners, but one is a litigator and one is a transactional attorney. You may still want to have your law firm act and be your designated attorney and have the other attorney act in that role. But there could be reasons why maybe, you want to appoint another attorney that locally that's willing to do it and practices in the same area as you. And if that should ever arise, that's kind of an extra wrinkle that you'd probably want to address within your succession plan and also with your partner, because And presumably, if you've got the consent actions, all partners would be executing those. So hopefully, if you implement the plan and the consent actions, that would address most of the issues that could arise. But just something to consider if you're practicing with an attorney that practices in a completely different area than yourself. So Section 14 discusses when this agreement can be terminated and when the appointments made hereunder can be changed. And just to summarize quickly, the planning attorney has the right to terminate the agreement at any time or to revoke an appointment at any time. As mentioned before, if there's terminating the plan early or revoking a designation, you may be obligated to make certain additional filings with the Client Security Commission and to update your designation with the State Bar Association and as to the change that occurs due to the termination or the revocation. So the planning attorney has that authority. However, if you're a designee under this agreement, we've somewhat limited your ability to just withdraw. So if planning attorney has not yet become disabled or died, you can withdraw at any time after you provide 30 days notice. If planning attorney has become disabled or is deceased and you decide you want to resign at such point, again, you have to give 30 days notice, but that only becomes effective assuming there's another attorney appointed hereunder who's willing to act as the designee. If there is no other attorney appointed hereunder, then it shall only become effective when another attorney has been appointed to step in and take over in the shoes of the designee. So in a nutshell, as long as there's another attorney who's agreed to step in your shoes, you can withdraw after giving appropriate notice. If there isn't someone who can step in your shoes, you're kind of on the hook until someone else gets appointed to step into your shoes. Section 15 just merely says the agreement can be amended by unanimous consent of the parties to the agreement. Section 16 contains the representations. In essence, the designees are just representing that they meet all of the requirements to become a designated attorney under the rule. Section 17 has our miscellaneous provisions, but the one I wanted to point out was the HIPAA waiver. So in essence, if you recall from when I started this in Section 3, some of the evidentiary things that the designee can rely on to know that he or she is to step in as the designee is notices and letters from physicians of the planning attorney. And to the extent required under HIPAA, the planning attorney is waiving whatever rights he has to the smallest extent necessary to allow that physician to give that information to your designee. And so with that, I think I've covered pretty much our full succession plan. This is the core document. And as I mentioned, all the other documents we prepared are really ancillary and intended to fully implement this core document. Again, it is just a form document and will need to be tailored for each particular attorney that decides to use it. So with that, I'm going to hand it back to Laura. She'll take you through these ancillary documents.
Thanks. So I'm just going to go through these fairly quickly so that we have time for questions. If I can figure out how to work this computer. Hopefully this doesn't make anybody sick, me flipping through this real fast. But so the first one that we've got in the materials are the estate planning documents. And this is just, like I said before, I think, when we were first talking about the documents available, just some sort of basic language. And again, you'll want to tailor this to your plan, both your estate plan and your business succession plan, which hopefully will dovetail together well. But this is just sort of some basic language, noting that the agreement exists. Presumably your executor or trustee isn't going to be the same person as your designated attorney, but he or she should know that it exists, and that the executor and trustee is directed to work with the designated attorney and to grant whatever authority is necessary, so that I guess the presumption is if you're trying to sell the practice, certainly as a going practice, that you want the designated attorney might be better equipped to kind of deal with that and the various kind of thorny issues that come up with that. And one thing to kind of think about with this and with all these documents is if you think the designated attorney or your alternate designee might want to purchase your practice or the land or whatever, that your executor or trustee would be able to take kind of the steps necessary to make sure that you're still getting the best price, or maybe if it's your designated attorney, to get the alternate designated attorney to kind of handle the sale of the practice, make sure that all those I's are dotted and T's are crossed, and that there aren't any conflicts of interest or any ethical violations, because selling a law practice can be complicated. And then directing to the extent necessary. So we put some language about the executor and the trustee paying whatever fees that you put in here for your designated attorney. But you might decide that that maybe that money should be coming directly out of the law firm, or however you want to set that up. But if you're going to pay them, you probably need to have your estate plan covered to make sure that they do in fact get paid. And so we've got it kind of in a will version and a revocable trust version. But they're pretty similar. It just depends, obviously, on what kind of plan you have. And then the next one is this durable limited power of attorney. So this is just kind of, again, a basic form that will look a lot like any other power of attorney that you might provide for a client. But you'll have kind of the same, how it becomes effective in terms of a disappearance or a temporary disability. I know, obviously, if you're not dead or been declared dead, then kind of when this is going to kick in, and you'll want to, again, make sure that it matches up with whatever you put in your business or your practice succession plan. And again, you probably want to address the temporary versus permanent powers, and I think that we've put some references to the existing agreement in here, and you might just want to reference that as well. And then it's effective until the earlier of either your recovery from whatever your incapacitation is, or until your death, and then of course you can also revoke it. And we've got the same HIPAA language, or very similar HIPAA language anyway, to the language that Travis just talked about in our succession plan. And again, so these are all the powers. So in this, at least draft version, we've kind of just said that they have the powers and it's attached to Exhibit A. If you don't want to have your whole business, your succession plan in there, depending on how you feel about sharing that with people, you might just want to make sure you've copied and pasted the specific powers right into the power of attorney. But the main thing is to make sure that everything kind of agrees with one another. And then we've just got some sort of basic plans here, or some basic language here for some of these other things about the liability, the compensation. You guys can read through all these on your own, I assume. Some of those are just kind of some basic form language. And the last couple of documents that we have are these consent actions that we've talked a little bit about. So this one is for a sole director and a sole shareholder of a corporation, basically just saying that you're doing this to kind of comply with the current rules, and that adopting the agreement and authorizing the designee or the alternate as appropriate to serve as the agent of your entity. And the corporation one that we've got, and the next one that would be up in all of your documents, is one for a single member LLC, but they're very similar, and I would think, Travis talked a little bit about if you had a small partnership or something, you might at least want to have some sort of consent action adopting the agreement and laying out maybe some of the basic stuff that you need, and they'd all be fairly similar to this, I would think. So those are just kind of the basic basic ancillary documents that we put together. And like I said, hopefully those can also be kind of helpful for you. The durable power of attorney, when we were originally drafting these, we didn't know that there was going to be the thing that you could print off, I guess, from the Bar Association, but hopefully this kind of can fill out and also, like I said, dovetail with your estate plan or your succession plan. And I think that's kind of the main thing to kind of keep in mind with all of these documents, to make sure that they all work together, that there aren't any changes between the documents, and thinking about how they all work together. Like I said, with the estate planning documents, if it's your executor or trustee who's kind of making the final decisions on sale, or if it's the designated attorney, things like that, and it kind of forces you to think about how those conflicts might arise and who's going to end up making those final decisions. So those are some of the other documents. I think that gives us about 15 minutes for questions.
The question is, what is a qualified attorney servicing association? And since you drafted the rule, I figured you can answer the question.
Actually, that's a defined term in the rule. If you look at 39.18 subparagraph 7, it tells us that a qualified lawyer servicing association it can be one of three things. It can be a bar association that has at least one member who is an Iowa lawyer admitted to practice here. It can be a company that is authorized to sell professional liability insurance here in Iowa. And the third possibility is an Iowa bank that has been approved with trust powers by the Iowa Department of Banking. Okay. Now, you probably are not aware, but the task force of the Bar Association that considered all this and formulated the revised rule had representation from a fairly wide range of interests. And those interests included, I think, both of the major professional liability carriers here in Iowa, and also a member of Iowa Trust and Estates Council who is very active as a trust officer with one of our banks. And the intent here was to at least provide a structure in which we might come up with entities willing to provide these services. And at this point, I'm not aware of any bar association or bank or liability carrier who's signed up yet to do this. Although I've heard that there has been at least some discussion, perhaps with one of the liability carriers about getting into this, because it does help limit risk, of course. So I would suggest that you want to stay tuned, because I think in the coming months you may see some developments here with respect to qualified lawyer servicing associations.
Thanks, Paul. Let me tie into that real quick. Another question we had is, if designated a bar association as one of the qualified attorney servicing associations, how do you go about doing that? I think I'll answer this. Right now, we really don't know. This is very new. We're rolling this out. Bar associations are working on it. I'm sure they're talking internally as to what they're going to do. But until you get further guidance, probably in the Iowa Lawyer and other announcements from us as to who's been designated a qualified legal servicing entity, and some bar associations have stepped forward and said, here's the mechanism. You need to contact this person or that person. We don't want you just willy-nilly putting the names of bar associations down. Okay? They need to agree what's there. And again, we're very early in this process. And that would be my 2 cents. Paul, you have any addition to that?
Well, I agree with all of that. And I think if I was the directing body of a bar association, the way I would look at operationalizing this would include a couple options. You know, one option, if you had enough traffic, so to speak, enough business, might be actually have someone on staff who can provide these services and offer them more or less as an adjunct to bar association membership. Another possibility, if you don't have enough traffic to support some dedicated staff to provide these kinds of services, you could think about having a panel of lawyers who are willing to come in incident to their regular practice to provide these kinds of services. And I would suggest that a bar association that looks at this consider not only providing services after the fact, in other words, after the designation becomes effective, but also look at providing services before the fact. In other words, coming out and providing assistance to sole practitioners in setting up their practices properly and organizing their practices and getting them organized so that these transitions, once they have to happen, can occur with some facility. Okay? I think there's a real opportunity for a bar or, frankly, one of the liability carriers to make this much more of a full service operation here. I think it would benefit all of us, and it certainly would benefit our clients.
This next question from the web comes across, and I'm going to direct it to Laura and Travis because it kind of ties in with your forms. And I'm going to paraphrase the question. It's basically, is it contemplated that a sole practitioner's designated attorney is one person or a number of people if the lawyer has a number of different areas of practice? That is, would we designate one attorney for my tax practice, one attorney for my trial work, or is it just having one? And obviously, from our form, from OPR's perspective, we really just have room for the one name. It's who's your designated attorney. But what about your forms? This really goes to the second tier as opposed to the first tier.
Yeah, that's a good question. The way they're currently drafted, I guess, we have, the presumption was you would only have one designated attorney handling all those roles. If you do have a multi-practice, it might make sense to have two different attorneys, in which case you could probably articulate that. You'd have to tailor, I think our form would be a good starting point, but you probably have to tailor a lot of that and be very specific as to, you know, who's got what authority, and there may be things that fall in the middle there, you know, because the designated attorney is managing their staff as well, maybe the staff work up for both practice areas, and so who's actually in charge of managing the staff, you know. So I think by trying to appoint two attorneys acting at the same time, it's probably going to get much more complicated, but I think you could still do it. Or,
Yeah, I was just going to say, I guess, kind of following up with what Trey said, that you can only appoint one person on the form. And to me, that would be kind of the person that's your official designated attorney. And within the agreement or the document that we've drafted, maybe you almost want to have like a subsection that says, you know, the files that I've designated in X folder or all my real estate matters or whatever goes to so-and-so. I mean, this kind of also goes back to what Travis said before. You're in a 2 or 3 person firm and you're the only one who does your kind of work. You might want to designate your partner or whomever to be your designated attorney, but you might want to specify that certain matters are handled by, you know, X attorney across town or whatever.
the other thing you could do is, you know, have one person act as your designated attorney and just note in there that with regard to your practice, you know, that you have 2 areas in which you practice, and on this other area, you would want the designated attorney to work closely with this third-party attorney. So instead of designating 2 attorneys, you have 1 designated attorney, but you're instructing them, I want you, and you can allocate as much authority as you need to this third party to handle that.
Trey, just as an aside, I think this was a perfect situation to consider a law firm as your designated entity, and look for a law firm that brings capabilities in the various areas of your practice, so that you essentially get a full service entity that can cover the things that need to